At this point in time, Bernstein? Mr. Bernstein. Hey, Mr. Bernstein.
Yes, sir.
The last witness after that is Susan McCormick. Mr. Bernstein.
Good afternoon, and thank you for allowing me time to tell my story today. Before we start, I did notice that Alan Friedberg was here from the Disciplinary Committee. I filed some complaints against him several months ago.
Friedberg, you still here or you left? Hey, Mr. Friedberg, how you doing?
And so I'd like the committee to look into where the missing complaints against him and Mr. Reardon are. They were filed several months ago. There's procedures to this. They're not following those. So if you could maybe find out where the complaints are at this time, that would be great. Okay.
You'll take care of that for me, right?
I didn't catch his first name.
Eliot Bernstein. Thank you. My story involves widespread corruption in the New York courts and New York investigatory bodies that have utterly failed in their civic duties to protect my rights and, in fact, have become the actual nemesis that blocks my rights. My name's Eliot Bernstein. I reside in Boca Raton, Florida, and I flew here to New York for the first hearings on June 8th and was prepared to testify when the coup occurred. I've traveled here under a medical treatment program to tell you about the saga of my company's Iviewit and what has earned the moniker Patentgate and its relation to the whistleblower case of Christine Andersen involving the New York courts and the disciplinary. I remind all of you of the conflict of interest disclosure forms I sent to this body and request that any and all conflicts be appropriately disclosed during the hearings or immediately hereafter. I am a husband and the father of 3 beautiful children, boys, and I'm also an inventor of the Iviewit technologies, which involve video and image compression, commonly referred to as mathematical scaling formulas, which are used on virtually all digital imaging and video devices. For example, the Hubble Space Telescope, my personal favorite, providing views into the universe and time like never seen before, using a technology that allows you to zoom on images without pixelation, as it was commonly referred to prior to my solving for that. The technologies are used by every internet service provider in the world that hosts a video, every computer that's playing a video. All digital television service providers use it. Mass of defense applications, such as space and flight simulators, use the technologies. Medical imaging devices use the technologies. Mapping programs, such as Google Earth, Google Maps, Google Street View, all use my technologies. Of course, I'm not getting paid for any of this, by the way. And the reason for that is because I hired patent lawyers. And we'll get into that. My technologies are now the subject of a $1 trillion, yes, $1 trillion lawsuit in federal court here in New York State as a result of theft, fraud, and other wrongful actions against my companies and myself, including death threats and an attempted murder. Yes, an attempted murder against my family by way of a car bombing of our family minivan in Boynton Beach, Florida, not Iraq, mind you, as my wife Candace and I were preparing to file papers against these same folks. Thus, please note the seriousness of my claims here, as attempted murder is a very serious charge. Full pictorial evidence of the car bombing, which was so strong it took out 3 cars next to it, can be found at www.iviewit.tv. It should be noted that the crimes to steal my intellectual properties were committed by my trusted lawyers and accountants, whom were retained to protect my inventions and instead fraudulently filed my inventions in others' names, including the patent attorney's own name. One patent attorney putting 90-plus patents into his own name here in Yonkers, while retained by my company during the time he was retained by my company. Yes, a patent attorney patenting his client's inventions in his own name, who it appears became more inventive than Edison after meeting me. You may think after hearing about a car bombing that safety is my #1 concern, but it's not. Bringing down the corruption that's infested.
Mr. Galashaw, we're here. You don't need the cameras. I know you're videotaping everything, but I don't think you need to have that camera on those two gentlemen. So, no, I know you're making a documentary, but you know this is a hearing, although it's open to the public. But we want to continue with these hearings. All right, Mr. Galashaw. Mr. Gallison. I'm sorry, Mr. Gallison.
I'm sorry, I do think it's my right, civil rights.
I've allowed you to do that for many times, but
My right, and you have to allow me to exercise my rights.
I can understand that. But at the same time, I don't want it to become a nuisance to a lot of people in here. Okay?
I don't think it's a nuisance to anyone. It's not a camera that shoots beams or anything. It just takes a picture. I'm not capturing your souls.
Allow the gentleman to continue documenting this hearing. It's not distracting anyone. He's quiet.
Let me make it clear. There's no problem documenting because we're having documenting. But if you're documenting this hearing, yes. But if you're singling out individuals, I have a problem with it. Okay? So that's my problem. So if you want me to
Lots of people.
if you want me to continue to have a hearings and keep this matter open to the public, I will. But I won't settle for.
Sir, with all respect, if I film these two gentlemen, you will stop having hearings. If I don't film the gentlemen, you will continue having hearings.
Yes.
Does anybody else find that strange and perhaps illegal?
Right not to be photographed too.
I'm allowing this to be testimony.
Okay, can we pick this up after me? Because I've got a limited time here.
Pardon me. Okay, I've got enough of them anyway.
Thank you. Go ahead, Mr. Bernstein.
Again, I was saying, you think a car bombing is the important thing to me in protecting my children, but it's not. What's really important is bringing down this disgusting corruption in the courts by lawyers, by judges, and it's out of control at this point. So my first priority is to pave the way for my children so that they don't have to pick up the battle and fight these. And I had a few words that just came, thank you, somebody, because what came to my head, I'm glad I didn't say. But, you know, if we don't stop him, it's going to be our kids stopping him. So that's right. And so let me continue on. It should be noted here that information has surfaced from another Florida businessman, one of Florida's wealthiest individuals, a 70-plus-year-old Monty Friedkin, that these very same criminals, disguised as lawyers from Proskauer and Foley Lardner, had in fact pulled a similar attempted heist of his intellectual properties immediately prior to preying upon me and my companies, exhibiting an alleged criminal enterprise cloaked as law firms and lawyers stealing inventions from inventors. This was the basis for my filing a RICO action against the entities comprising the criminal enterprise, as it was learned that several law firms and lawyers involved in the Friedkin attempted theft and my own were working together. Later it was learned that these powerfully connected law firms and lawyers had penetrated deep within the United States Patent Office and other government agencies, and that part of the criminal enterprise operates to block due process of any victims that may challenge them, infiltrating courts or investigatory agencies to block complaints against them, similar to what the whistleblower Christine Andersen has previously testified about regarding obstruction of justice for favored lawyers within the department, destruction of documents, threats, coercion, etc. In fact, Andersen, my hero, in her original complaints, mentions the Iviewit companies in her original lawsuit filing as one of the reasons leading to physical abuse and other crimes against her. In fact, my federal $1 trillion lawsuit was marked legally related by Federal District Court Judge Shira Schindlin to federal whistleblower case Andersen, who worked as a principal attorney at the Departmental Disciplinary Committee. As you should be aware, the Andersen whistleblower case has been slated for a public trial, currently slated for October 13th. Multiple attorneys regulated by the courts of New York, and specifically the New York First Department, have been involved in the Iviewit matters for nearly 10 years. Going back to 1998, when my technologies were first being tested, used, and in the process of securing patents and related intellectual property rights to protect them. The technologies were tested and used at Real 3D Inc. Labs located on Lockheed Martin property in Orlando, Florida. Real 3D at the time was owned by Lockheed, the Intel Corporation, and Silicon Graphics. It should be noted here that Lockheed is the largest purveyor of digital imaging and video technologies on the planet Earth. Leading engineers at Real 3D who tested and used my technologies deemed them priceless, while other experts in the industry called them the holy grail of the Internet, including favorable comments from Hassan Mia, an industry-recognized expert at the CAA Intel Multimedia Labs, which took the Internet from a text-based medium to one with rich multimedia, which previously was only banner ads and very small, grainy images. Video really didn't exist in any usable form for Internet applications due to the bandwidth limitations. The inventions were backbone in nature by providing the mathematical formula that permitted scaling and compression of video and solving for pixel distortion, and also simultaneously reduced bandwidth usage by 75%. Now, please just think for a moment that 10 years ago, the technologies created a 75% increase in available bandwidth for transmission across the Internet and television, which allowed video to be streamed or downloaded at full screen, full frame rate capabilities commonly found today on every website. And due to the ability to transmit using the technologies at much lower bandwidths, the technologies open the door for markets entirely new, such as Internet video, cell phone videos, and video conferencing systems through the Internet. Prior, thought impossible. As for the effect the technologies had on television, for example, the bandwidth savings from scaling video from the prior interlacing methods used since the invention of television essentially permitted 75% more channels for content distribution on television. And I'm sure all of you can remember about 10 years ago, your channel bandwidth went up and your cable channels increased dramatically. That was due to the inventions. Therefore, you have more Yankee games, more DVD channels.
You're the man responsible for all that?
I am. I'm the man responsible, but not getting paid yet. But that we're working on that here. Okay. Let me just skip because I know you guys are in a time frame. The technology is used on everything. Digital, we already went through all that. Enter Proskauer Rose, the law firm.
Quickly, work for him. Disclaimer, I used to work for him.
Yes, I understand. And I appreciate your upfront honesty and disclosure with that, by the way. That's a sign that's missing in the legal profession today. The conflicts of interest that are rampant in my case will blow you away here. I mean, this is some stuff. We find the head of the New York State Bar at one point, former Stephen Crane, handling complaints against himself at the First Department DDC while he's an officer of the DDC, with Tom Cahill covering it up. And thank God for another hero in this world, Catherine O'Hagan Wolf. She exposed it. She told me when she caught them lying and playing these games to go file a complaint with the First Department. I'll get to that in a moment. Let me take back to Proskauer. Quickly on the scene in Boca at the invention time was Proskauer Rose to patent the technologies. Now, they didn't have a patent division at the time, but they didn't tell me that. They told me they were going back to New York to check with their, New York offices if they could secure patents for me. What they did, for example, it was represented to the Iviewit company initially that attorney Kenneth Rubenstein was a Proskauer partner. To the contrary, reports showed Rubenstein was at the law firm Meltzer Lippy on Long Island at the time, one of the many named defendants in my $1 trillion RICO antitrust suit.
What's the status of that RICO case?
It's at the Second Circuit.
Okay, so just to come on, Mr. Nieves, this is light. We don't want to be in darkness. So what I want to find out is just getting what you're saying is the misconduct that was initiated by the attorneys, and since that period